And my mama got to take care of. I'm just tired. And I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I miss my daughter's graduation. She spoke at West graduation. I was not there. I'm tired. My baby asked me why I'm the only mom. I'm not at mom's and muffins. This is embarrassing for my kids. I want to go for my kids. That's what a chance to do for me. Mama, thank you.
Good morning. Are you Matthew Wadsworth?
Yes, ma'am.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from this one.
All right, Mr. Rojas, you may proceed.
And he tells me he's ready to make that change, and he does have some statements to make to you at the appropriate time.
It's a straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on. But in my head, our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. I'm sorry, 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. And we started fighting. I was losing, and I said, if you do give me the chance, what I need is some help staying on my meds. Because I start feeling like I'm doing better sometimes. And then I stopped taking them. When I stopped taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. White, even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think 21 felony convictions. 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of the, and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements and things like that. So that's 38 felonies. The last, and I get a lot of this was from 02.
I believe probation is absolutely right, that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8 years TDC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff. All right, are you Rebecca Rideau?
Yes, ma'am.
And Ms. Rideau was previously in court, entered pleas of guilty in cause numbers 230928, 232106, 232107, and 241925. All of those were theft of property with previous convictions. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
I think so.
State has, Judge.
And there was no agreement. This was just open to the court. Is that correct?
Yes, Your Honor.
I believe so, Your Honor. I didn't represent her at the stage where she entered the plea.
Okay.
My understanding is that
They were open. And are there any additions or corrections to the pre-sentence report?
None from defendant.
Not from the state, Judge.
Your Honor, I would just said that seems to be an aberrant practice as far as the harshness that the state is attempting to exert on this defendant. And I don't know that it stands out from the queue of other cases before this court to deserve such treatment, but it is what it is. I would just observe, first of all, regarding the state's posture on consecutive sentences to denial of discretionary jail credit. The defense certainly has criminal history, but it's not to such an extent or degree in the circumstances. The individual cases aren't such to the extreme degree that it would warrant accumulation, and certainly the denial of her jail credit is something that is problematic. I don't know exactly which jail credit the state is attempting to deny her, but obviously if she's been in pretrial detention on these cases, it seemed that she would be entitled to that jail credit without much general discharge. And there was notations there as far as the pre-sentence report that would involve some health issues. I believe her to be mentally competent. Now, I, of course, wasn't her attorney when she entered the plea, but I would assume that she was mentally competent then as well. Although, as I said, she does have mental health history. I think that plays into her present situation with the theft cases that she has. You will note in the pre-sentence report where it's indicated that she was unable to afford the mental health treatment and the pharmacological remedies that are provided through prescriptions, and that she was self-medicating and had turned to theft in an attempt to maintain funds necessary to self-medicate.
And my mom got to take care of. I'm just tired. And I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I'm old. I miss my daughter's graduation. She spoke at West graduation. I was not there. I'm tired. My baby asks me why I'm the only mom. I'm not at mom's and muffins. This is embarrassing for my kids. I want to go for my kids. That's what a chance to do for me. You know, Mama, thank you.
Sure. So there was a robbery that you got some time for in 21, and then you're here now on 4 more theft cases. And so, I mean, it's unfortunate and it's sad for your family, but no one put you here but yourself. Mr.
Judge, you
Coleman, I know what
Yeah,
you're,
you've essentially hit the things that I wanted to hit. That in addition to what I put in my sentencing memo, I won't belabor that, Judge. The only thing I would add is she says she's tired of this. I tell you who else is tired of this. It's our local store owners and business owners who are tired of people just walking in and taking what they want from them. She stole from a sporting goods store, from JCPenney, from another clothing store on a couple of occasions. They're tired of it too. They're the same old song. Just different defendant. I apologize. Give me another chance. I've got all these issues. In fact, I go one step further than the same old song. It's the greatest hits, Judge. It's what you hear time and time again. And I'm sure she said it back then, but
I can't give the max and do that.
that's my understanding.
That's your understanding.
Yes, that's it in a nutshell, Judge. And I just say this is a case for that to be considered. And I also say this is the appropriate case to accumulate her sentence, Judge. She needs, in my opinion, some stronger medicine than what she's received in the past in order to impress upon her the fact that she needs to stop engaging in this kind of behavior, Judge. Thanks, that's all I have.
Thank you.
I would just argue from the standpoint of equal protection as far as the other defendants listed.
Well, so here's, speak up so she can hear.
I would argue from the standpoint of equal protection of laws, Your Honor, what distinguishes her from the other defendants that have been before this court and are similarly situated with similar criminal histories?
Well, here's where, here's where I am on this. I don't disagree with Mr. Coleman. I appreciate that he's gone out and tried to figure out some stronger things to do on some of these cases where we are stuck with state jail felonies. I've been very frustrated with that in the past. I don't know that this is the one to start with either necessarily, but it's not going to be out of the realm of possibility, depending on someone's criminal history, what their prior sentences were, and I don't fully disagree that this isn't one of them. I'm not going to do that this time, but I do appreciate the thought that went into this and don't necessarily disagree that there's going to be a time that this might happen, including to you if you continue to do what you've been doing for your whole life. Because if you're back in here after today on a theft, I can assure you that Mr. Coleman will remind me what he asked me to do that I didn't do. And I will on that. Do you understand? So if you want to be there for your kids, then you got to figure out something other than stealing. I'm going to find in all of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 0928, find you guilty of the state jail felony of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2106, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2107, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1925, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases, I am going to run them concurrently, which means together at the same time. Part of the reason I did the 24 months is because I'm going to see that when you come back, that this is the max on a state jail felony you can get. So next time, whoever's here, if it's me or someone else, is going to see that you have progressively gotten worse, your sentences have gotten worse, and when someone like Mr. Coleman files something asking that these run consecutive or that we deny credit, that's likely to happen. I'm handing you in all four of your cases the trial court certifications. These show that these were not agreements, and so you have not waived your right to appeal. You can talk to Mr. Kimler about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kimler. Good luck to you, ma'am. You can go back with the bailiff. Thank you for